We'll call the case of Kendra Malice versus Justin Malice. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Alex Goldman, representing the plaintiff, Kendra. And Ms. Kendra appears to be present, as is the defendant, Justin. Good morning, everyone.
Good morning, Your Honor.
Good morning, Your Honor.
Pretty short-term marriage here, Mr. Goldman, but there are issues that need to be discussed in mediation. Is that correct?
That's correct.
Okay. Mr. Malice, the court's going to complete a pretrial summary just so I can identify the issues. And then the court will order that the two of you engage in mediation with Mr. Walker from the front of the court and then appear before the court for a continued pretrial conference thereafter. Mr. Goldman, you received a date from Mr. Walker that's agreed with everyone's schedule. Is that correct?
It's correct.
And what is that? What is that date?
July 29th at 8:30 a.m.
I'm sorry, 9:30?
8:30.
8:30. Thank you. Right. So Mr. Malice will provide you with a copy of we'll provide you with Mr. Walker's Zoom ID number. Mr. Goldman, what do you believe to be the issues? Is there real estate to be addressed?
It's primarily custody and parenting time, Your Honor. There may be some personal property issues, but the majority is going to be custody and parenting time.
Okay. You can also make a note to Mr. Goldman, the issue of the fee waiver. That needs to be discussed during mediation if there's any assets, or I don't know if Mr. Malice is on public assistance. Mr. Malice, you in public assistance, Mr. Malice?
No, sir.
All right. There is an issue, and I'm going to bring it to your attention now because it needs to be addressed. There's an issue of a filing fee that needs to be paid. Ms. Malice is on public assistance, so the court cannot order her to pay it. That was suspended by the county clerk. It's $255. So make a note of that. $255 needs to be paid to the Monroe County Clerk.
Okay.
Obviously, we'll address that further, but obviously, if you can pay it between now and when we next come back to court, that's great. Then we don't need to include that language in the judgment, but that has to be addressed. That's paid to the county clerk. All you got to do is you can pay by credit card, but they're going to charge a fee. You're better off just coming in with cash and paying that. So county clerk's on the second floor of the courthouse.
Thank you, Your Honor.
So please note that, and hopefully you can have that paid before you come back. The parties separated in January of this year. Is that correct, Mr. Goldman?
Yes, Your Honor.
Okay. Mr. Malice, do you still reside in?
No, Your Honor.
You have a new address?
Yes, Your Honor.
Okay, we're going to mail you a notice of a continued pretrial. So
I was trying to keep my address private from Kendra. I was having a lot of problems with her contacting and coming over and being aggressive.
Okay, well, is it a family member that lives at Pierce Street?
Yes.
Okay, we need to mail you a notice for the upcoming pretrial conference mediation.
I still receive mail at that address, yes.
Okay, we will keep that address for mailing purposes then. That's fine.
Thank you.
All right, so Mr. Malice, I will tell you that the best resolution of custody parenting time is one which you and Ms. Kendra can agree upon. You know what's best for your child or children, and how many there are. 2 children. You don't want to strange like the court making decisions like parenting time. You know what your work schedule is like. So the court would encourage you to keep an open mind, and the same with you, Ms. Kendra, keep an open mind and reach agreement as to those things. They're always subject to modification. Custody and parenting time, upon a change of circumstances, are always subject to modification. So decide what's best for your children right now. Obviously, things may be different 5 years from now, and the court can always modify that. So keep an open mind as you engage in mediation. Hopefully we can resolve things when we come back in July. And Mr. Malice, do you have any questions for the court?
No, Your Honor.
All right, Mr. Goldman, anything further this morning?
No, Your Honor. Thank you.
All right, again, the court will send out a pretrial summary, order the parties, and notice on your calendar, Mr. Malice. You can mediate with Mr. Walker July 29th at 8:30. And after that, appear before the court for a continued pretrial conference. If in fact there's no agreement, then the court will schedule a trial date.
Yes, Your Honor.
Is parenting time occurring right now, Mr. Goldman? Are there parties communicating?
The parties are communicating. Parenting time has not occurred.
Okay.
There are safety concerns. Yeah.
I don't know, is it because Ms. Kendra is concerned about the environment that Mr. Malice is residing in right now? Is that the issue? There's
Substance abuse and mental health concerns.
Okay. So address those concerns, Mr. Malice. If you maybe get a letter from a counselor, somebody, if you're dealing with someone, just to provide Ms. Kendra with some assurance that you can capably parent these children without supervision.
I'm so sorry, Your Honor. I am currently in treatment and I do have proofs of them. She has just been unwilling to hear me out and to accept them as proofs.
Okay, what the court's suggesting is get something in writing from your therapist, your counselor, updated letter in terms of verifying that you are engaging in regular continued counseling and treatment and the prognosis is good, whatever. You would secure some letter to present that to the mediator, to Mr. Goldman, when you come back.
Yes, Your Honor. Thank you.
We just want to make sure the children are safe and the environment is appropriate. At some point in time, you have to disclose where you live. Obviously, you should maybe communicate if you can't communicate civilly, then you can communicate via app close, which is an app on your phone, and it's all recorded. It's all in writing, and it should only
the disclosure
should be only regarding the children.
The disclosure of my address has been being kept from her for reasons of her aggressiveness. Okay. It's nothing else. It's already been documented. Okay. There's cops been involved.
Okay, and again, obviously, if she comes to the home and when you exchange the child, just meet at the police department, a neutral location. But obviously, it's a legitimate concern in terms of where the children will be when they're with you. So that's got to be addressed sometime in the future. In any event, that will conclude this pretrial conference. We can zoom out, and we will mail everyone a pretrial summary. We'll see you back on July 29th after 8:30 mediation with Mr. Walker. Thank you, Mr. Goldman. Have a good rest of the day. The matter was scheduled for mediation 8:30. It's now 9 a.m. The present is Attorney Alex Goldman, representing the plaintiff Kendra Malice. Ms. Malice is present. Sir, are you Justin Malice?
Yes, Your Honor.
Mr. Malice and Mr. Goldman, have the parties reached their own agreement this morning?
Only to attend another mediation. Mr. Malice recently acquired counsel who was unable to be here this morning, so we are going to mediate again with the assistance of his attorney.
We have a one-year marriage. Mr. Malice, there's no attorney appearance. This court will not adjourn this matter. I'm ordering you to engage. This has been scheduled for some time. The court mailed out this notice on May 31st. We're not going to play games, Mr. Malice. The court has not received the courtesy of a phone call from an attorney. There's no appearance. Mr. Goldman, have you received the notice from an attorney?
No, Your Honor.
Okay, this has been scheduled. These are valuable time slots, Mr. Malice. We just can't play games here. So I'm going to order you to continue mediation. Get to your attorney on the phone. I mean, he should be here. It's a one-year marriage. There's no real estate. You've got a fee waiver. Did Mr. Malice pay the fee waiver of the $255? Mr. Malice,
Your Honor, I have since lost my job. Since the last time we were here in court.
I'm asking you whether you paid it or not.
No, Your Honor, I have not.
Okay, so there needs to be addressed in the judgment. And there's personal property, custody, and parenting time. So the party has been separated since January. What items of personal property are in dispute? So I'm going to, Mr. Walker, good morning. I'm going to have you meet with the parties. Mr. Malice, if you want an attorney, you call him right now. Tell me he needs to zoom in. We're going to mediate this matter this morning.
Okay, give me a moment, please.
There are, well, I'm not going to waste Mr. Walker's time. It's scheduled 8:30. Mr. Walker has a very busy schedule today. Did Mr. Malice zoom out?
He went to call his attorney.
Okay. All right. He just I don't know if he calls attorney, but I mean, this is a pretty simple matter, isn't it, Mr. Goldman?
Your Honor, I think the custody and parenting time issues are going to be contentious.
Okay. What's been the practice over the last 7 months?
The children have been in Miss Malice's exclusive care, and Mr. Malice has not attempted to see them.
Well, that's right there. That gives you a pretty good idea. If he's not filed a petition for parenting time.
I agree, Your Honor. I was, I'll look forward to hearing what his attorney has to say.
All right. Mr. Malice, were you able to reach your attorney?
No, my attorney is on bed rest. He just got out of surgery for a heart valve. So I don't think I'm going to be able to get him on the phone right now.
All right. Again, all right, I'm gonna have you talk with Mr. Walker. It sounds like personal property is not really an issue. Mr. Malice, where'd you go? Well, what items of personal property are in dispute? I mean, it sounds like from Mr. Goldman, it's primarily custody parenting time. The court has been informed you've not made any effort to petition the court for parenting time. So it appears pretty clear in terms of what the court's going to look at in terms of custody parenting time. What's happened in the last 7 months? What's happened since you separated? So with that, talk with Mr. Walker. Let's see if we put the proofs on the record today, and let's move forward. And you can also give the court a date when we come back in terms of when you can pay that $255 filing fee. Ms. Malice is still on public assistance. Is that correct, Mr. Goldman?
Yes, Your Honor.
All right, we're gonna have you go back into meet with Mr. Walker again. Mr. Walker, if you don't mind, talk with the parties a little bit further this morning. I'll be available all morning.
Thank you, Your Honor.
All right, thank you.
Sarah,
Yes.
will you please put the parties in separate rooms? We're going to mediate in separate rooms.
Okay.
Court will call the case of Ashley Bailey versus Armand Bailey. For the record, this matter is before the court for a continued pretrial conference. The same is being conducted via Zoom. Present is Attorney Michael Keeney representing the plaintiff, Ashley Bailey. Ms. Bailey is present. Defendant Armand Bailey is also present. Good morning, everyone.
Good morning, Your Honor.
Good morning.
Good morning. It's of course recollection, Mr. Keeney, that the only issue preventing the party from getting divorced is we need to address the paternity of this child born to Miss Bailey during the marriage of the parties. Is that correct?
That's correct, Your Honor.
And Miss Bailey was to secure the presence of one Brandon Bragg, the alleged bio dad. Is Brandon Bragg present this morning?
Unfortunately not, Your Honor. Since our last hearing, Mr. Bragg has become unavailable due to medical reasons, both physical and potentially mental reasons. And as such, we are here today to ask the court for guidance on how to proceed with this matter. Since Mr. Bragg is unavailable and unwilling and potentially unable to speak with me or Miss Bailey or the court.
Then I think what we need is some DNA testing to be performed with Mr. Bailey and the minor child.
Okay, Your Honor,
So
we can certainly secure that. And would Your Honor be agreeable to allowing the DNA testing to be over the counter, or would he require it be done at a facility?
What's been your experience, Mr. Keeney? Obviously, the court's not opposed to a over the counter if, in fact, we have testimony from both parties that they both are in agreement that Mr. Armand is not the biological father of this minor child. And presumably that both parties would attest to that, correct?
That's correct, Your Honor. And in my previous experience is that over-the-counter tests have been sufficient to prove the necessary factors in these type of cases. So if Your Honor would permit, I think the parties would move forward with over-the-counter DNA testing.
With over-the-counter testing, will that actually produce a written report?
It will, Your Honor. It will produce the ones that I've seen, they've produced both physical test results that are mailed to the mother, and then they also produce a virtual result that we can go ahead and print out so we don't have to wait.
Very well. So who will initiate that testing? Well, obviously Miss Bailey, she should purchase that test. Is that correct? Or
yes,
maybe
Your
Mr.
Honor.
Bailey, it's in your best interest too. because you are presumed to be the biological father of this child. So the court would suggest if Miss Bailey can't afford it, that even you pay the cost of the test. I have no idea what an over-the-counter DNA test costs, but that hopefully will exclude you as being the biological father of Mr. Bailey. Otherwise, you'd be on the hook for supporting this child.
Your Honor, I believe that Miss Bailey is prepared to purchase and pay for the test. However, if Mr. Bailey agrees to split the cost with her, she'd be open to that. But we don't want this one issue to prolong this divorce any longer.
Okay. All right. So Miss Bailey will go ahead and secure that test and obviously provide a receipt or something to Mr. Bailey. Hopefully Mr. Bailey will contribute toward the expense of that test. And Miss Bailey then will contact Mr. Bailey to make arrangements to have the cystic con swab test, correct?
Correct, Your Honor.
Okay, so the parties will get together.
I live in California. Like, how I'm gonna do this DNA test?
Okay. We have an address for you in Detroit, Michigan.
I can send it to you by the mail, Armand.
All right, so Mr. Bailey, you have a new address, correct?
Yes, that's correct.
I'm sorry?
I said yes, that's correct. But you
Okay,
can
well,
still
give us your new address. Give us your new address so that we.
You can send stuff there. That's my mom's house.
I'm sorry. You look like you're real tired this morning. You're rubbing your eyes. You're saying that this Everett Street home is your mother's address?
Yes.
Okay. Do you regularly check the mail? Does your mom regularly check the mail and talk with you every day?
Yes.
So you want all the future notice mailed to you at that address? Is that correct?
Yes.
Are you going to be back to Michigan at all this summer?
Nah, I live in California.
Mr. Keeney, obviously the court, we don't know if Mr. Bailey's going to be submitted to this test, or we have some third party.
Your Honor, what I've done in the past, whenever we've done over-the-counter tests, is we have basically done it in a live session. So I can send Mr. Bailey a Zoom link or a Google Meetings link, and I can watch him perform the test. If Your Honor would find that to be sufficient, we can go ahead and do that.
So you would attest to the fact that you observed it and then Mr. Bailey identified himself and he in fact submitted the, well, but then how do we know that's the same sample that's mailed back to Miss Bailey?
I'm not sure how to overcome that, Your Honor, other than providing an affidavit or something along that Mr. Armand would go ahead and sign, attesting to the fact that it is, in fact, his DNA that is being returned to Miss Bailey.
All right, and perhaps after we have the results, Mr. Bailey can provide sworn testimony to that fact, Mr. Keeney, to address that.
Yes, Your
Honor. All right, so the court's going to propose we take the proofs this morning, the staff jurisdiction as a breakdown, and then we'll schedule a continued pretrial conference for those DNA results, and hopefully once we get those, that's only issue, correct, Mr. Keeney, that's preventing these parties from getting divorced?
Correct, Your Honor.
Right, Miss Bailey, please do not get pregnant again, so we don't complicate this divorce action, because if so, it's going to delay things. Okay, she's shaking her head yes, hopefully she understands that.
No problem. There won't be any more babies, believe me.
Okay, we also have an issue of a fee waiver. Mr. Bailey, are you currently employed?
Yes, I am.
Are you currently employed?
I say yes, I am.
Okay, there's a filing fee of $255 has to be paid. Miss Bailey's on public assistance. So that needs to be paid before we come back to court. You can pay that to the Monroe County Clerk. We can give you a phone number. You can pay it. You can call them and pay it by credit card over the phone.
You said how much is it?
$255. So make a note. Do you have a piece of paper and a pen there? We can give you the phone number, and the court will order you pay that before we come back to court. So that's addressed. The taxpayer should not have to pay that filing fee. Mr. Bailey, I mean, you could have started this divorce action on your own years ago. But in any event, are you ready with for the phone number?
Yeah.
Okay, and you call the county clerk and you give them the name, give them the case number. You have obviously paperwork in California correct about this case. You have the case number.
Yes, I got all the paperwork at home at my mom's house. She can send me the
Okay.
information.
Okay, let me know when you got a piece of paper and a pen.
All right, go ahead.
Let me know when you have a piece of paper and a pen.
I do.
Oh, okay. So your case number, first of all, your case number is 20.
7044.
Did we able to capture that, Mr. Bailey?
Yeah, I got all that.
Sorry. Okay, all right. So please take care of that before we come back to court. What do you suggest time frame for adjournment, Mr. Keeney? 5 days?
I believe that potentially 4 to 6 weeks should be sufficient in order to get the DNA test results back.
Okay. All right, so we'll try to schedule it later in the morning for Mr. Bailey since he's in California. How about July 19th at 10 a.m.? That'll be Michigan time. I don't know what the difference is. Or we'll get a 2-hour difference, 3 hours from California, Mr. Bailey.
3 hours.
3 hours.
Okay. I guess we moved to 10:30. How about if we can move it to 10:30, Mr. Bailey?
That's fine.
So it'll be 7:30 your time. Mr. Keeney, does that work with your schedule, July 19th, 10:30?
Yes, Your Honor. Thank you.
Right. So the whole goal is to hopefully finalize things on that date. Mr. Bailey, get you divorced. And so in the interim, you've got to work with Miss Bailey. And I know she needs an address for you so she can mail you this DNA testing. And it's just a cotton swab. You communicate with Mr. Keeney. Mr. Keeney, of course, if you can assist the court in monitoring, make sure that Mr. Bailey's the one submitting that DNA testing. So hopefully we'll get that done as soon as possible, Ms. Bailey, get the secure and purchase that to test as soon as possible because it could take weeks for the lab to test it. You need to unmute yourself, Ms. Bailey.
Oh, I apologize. Yes, sir.
All right, so we're going to take some brief testimony just to establish jurisdiction. There's been a breakdown, and we'll address the issue of paternity as well. Ms. Bailey, can you both please raise your right hand to be sworn, please? Do you both solemnly swear affirm that the testimony about giving this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. Ms. Keeney, if you begin with Ms. Bailey, please, you can address take the proofs, and then you can address the issue of paternity for this child, please.
Yes, Your Honor. Thank you. Ashley, go ahead and state your name for the record.
Ashley Bailey?
Did you instruct our office to file a complaint for divorce on or about November 20th of 2023?
Yes, sir.
Had you lived in Monroe County for at least 10 days at the time of filing?
Yes, sir.
Complaint? Had you lived in Michigan for at least 6 months?
Yes, sir.
Were all the allegations in the complaint for divorce true at the time of filing?
Yes, sir.
Are they still true today?
Yes, sir.
Were any minor children born during your marriage?
Yes, sir.
And it is my understanding that you were asking the court to revoke Mr. Bailey's paternity for this child. Is that correct?
Yes, sir.
No other minor children were born other than correct?
No, not for me. No.
Correct. Thank you for that. And Carson's age, he is under 3 years old. Is that correct?
Yes, sir. He'll be 2 in September.
Thank you. Is there any debt that needs to be divided?
No, sir.
Is there any property that needs to be divided?
No, sir.
And are you aware that we are not asking the court to award you spousal support?
Yes, sir. I don't need anything.
Do you understand that this is a permanent ban to spousal support, which means you cannot come to court later and ask for spousal support at a later date?
Yes, sir. I don't care.
Would you agree there's been a breakdown of the marriage to the extent that the objects of matrimony have been destroyed and there is no reasonable likelihood of reconciliation?
Exactly. It's been 8 years.
Are you asking the court to restore your last name as part of this divorce?
Yes.
Thank you. Can you no further questions, Your Honor.
Thank you, Mr. Keeney. Ms. Bailey, this minor child Carson was born in September of 2022. Is that correct?
Yes, sir.
And who do you believe to be the biological father of that minor child?
His father is Brandon Bragg, but Brandon is going through his...
Understand. So it is your belief that Armin Bailey is not the biological father. Is that correct?
That's correct.
So would you acknowledge that you had no sexual relations with Mr. Bailey 9 months prior to the birth of Brandon?
Exactly. It's been 8 years. Armand's been in California for a long time.
Okay. All right, so Mr. Bailey, could you please state your name for the record?
Armand Bailey.
Mr. Bailey, did you hear the testimony of your wife, Ashley, this morning?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Now, you heard her testimony that there was a child born during your marriage, namely a child by the name of Brandon Bragg, born in September of 2022.
Yes, I'm a baby.
Are you the father of that child?
No.
And you're asking the court to revoke paternity and to declare and determine that one Brandon Bragg is the biological father of that child, Carson. Is that correct?
I don't know the father's name.
You're asking this court to revoke paternity and determine you are not the father, correct?
Yeah.
Okay. Do you have any questions for the court, Mr. Bailey?
No, no, go ahead.
And you agree there's nothing at issue in this divorce case other than determining the paternity of this child. Is that correct?
Yes.
All right. Mr. Key, do you have any questions, Mr. Bailey?
I do not, Your Honor. Thank you.
And do you have means by which to reach Mr. Bailey? Do you have a phone number for him?
I do, Your Honor.
All right, so Mr. Bailey, keep in contact with Mr. Keeney so that we can finalize this. So you can move on with your life. Let's clear up this marital status of you and Miss Bailey.
Okay.
All right, so we need to appear on July 19th, and hopefully Mr. Keeney will have a judgment divorce prepared, and he can email that to you, and you can review that and approve it, and we can get you divorced on July 19th. That's the whole goal here, okay?
Mm-hmm.
So we'll mail to your mother's address a notice to appear July 19th, 10:30 for a final pretrial conference. Hopefully, not only will have DNA test results, but we'll also have a judgment divorce. Anything further, Mr. Keeney?
No, Your Honor. Thank you.
Right, thank you for your assistance. Based on the testimony that's been presented this morning, as well as the file this case, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marital relations to the extent that the objects of matrimony have been destroyed. There is no reasonable chance of reconciliation. However, at this point in time, the court will reserve all standing issues, including the paternity of this child born during the marriage, Brandon Bragg. The court will address these issues on July 19th, 2024, 10:30 a.m. via Zoom. All right, that concludes this hearing. We'll mail out notice. We'll see him back on July 19th, 10:30. Mr. Bailey, do get that DNA test kit together as soon as possible and coordinate with Mr. Keeney, get that to Mr. Bailey so that can be accomplished. I don't know whether we take whose sample we take first. I'm not sure what's the recommended procedure, but Mr. Keeney, I'm sure can assist you with all that.
Yes, Your Honor. I'll be sure to do that.
Thank you. All right, that concludes my record. Zoom out. Have the rest of the day.
Thank you.
Is Armand Bailey present?
He is not, Your Honor.
Okay, let's see, OPC, what is that? Does that mean someone's on the phone? It said the green leaf says OPC. I thought it was when someone was calling by phone. Okay, all right. It appears that Mr. Bailey has failed to appear. This pretrial conference was scheduled for 10:30 a.m. It's now at 10:48 a.m. Mr. Keeney, your client attempted to text or reach Mr. Bailey to get him to appear this morning?
Both, Your Honor. She has sent him a text about an hour and a half before today's hearing, and then she also called him twice while we were with friend of the court, and he has not responded.
Okay. The court notes that the proofs were taken on May. First of all, the court would note for the record that Mr. Bailey has not contacted the court this morning. Court recalls we did take the proofs back in May. The court agreed to allow the parties to submit a DNA over-the-counter DNA testing. Was that accomplished or?
Unfortunately, no, Your Honor. Mr. Bailey has been uncooperative this entire time, and originally he did contact Miss Bailey and requested that she try to get an adjournment, but he had been completely unresponsive leading up to that point and completely unresponsive after she tried getting more information regarding the reason for the adjournment. And so we felt it was best for us to come to the court today, and so the court could give us some direction on how it would like to proceed. And so, Your Honor, I did speak with Miss Bailey and told her it seems like there are a couple of options here. One of them being that Mr. Bailey be ordered to coordinate and pay for DNA testing done at a facility. However, he is out of state, so that coordination could prove to be difficult. The other option I talked with Miss Bailey about was the possibility of Your Honor issuing a default judgment of divorce today, and the parties could attempt to address the revocation of paternity at a later date. I know that the court would prefer that everything be taken care of today, but as of now, the biological father in question is unable and unwilling to cooperate due to some mental health issues, and unfortunately, Mr. Bailey has proven to be uncooperative as well.
Thank you, Mr. Keeney. So the alleged biological father, Brandon Bragg, is not he's not capable of submitting to DNA testing?
Correct, Your Honor. It's unclear whether he's actually capable and just refusing, but last Miss Bailey spoke of him, he was going to enter himself into a facility. And has since severed all communication with Miss Bailey. All
right. Well, again, all the court can do is determine that Armand Bailey is in fact the biological father by statute. So yes, I believe the proper steps is to proceed with entry of the default judgment of divorce, Mr. Keeney. Mr. Bailey then will have to file a motion to revoke paternity down the road. Well, the address the court has for Mr. Bailey is that mailing of the notice for pretrial today. It was now returned as being undeliverable, so the court will assume that address is still good. Did Mr. Bailey ever file an answer to the complaint?
He did not, Your Honor.
Okay. Trying to see whether you previously filed the default with the clerk.
I have not, Your Honor. I was hoping that we'd be able to resolve everything through a consent judgment of divorce, but that now seems impossible.
All right. All right, so if you want to then, so your suggestion is to enter a default with the clerk and mail that out to Mr. Bill along with a proposed default judgment.
Yes, Your Honor, that is correct.
All right, we can give you a date for that. You're available on August 22nd, that Thursday.
Yes, it appears so, Your Honor.
Okay. Either do 10:30 or we can do 2:30 or 3.
I have no preference, Your Honor.
Okay, court prefer 10:30.
Okay.
So the court will mail out a final pretrial conference to both you and to Mr. Bailey for August 22nd. Will that give you enough time?
It will, Your Honor. And so just to give Your Honor an update on our office, I will no longer be with our office as of July 31st. So Alex Goman from our office will be taking over this case. He has been made aware of this, and I just checked his calendar and placed the hearing date on his calendar. And I've also spoken with Ms. Bailey about Mr. Goman finishing up this case.
Well, we're going to miss you, Mr. Keeney. I'm saddened to hear that because you've been wonderful to work with.
Well, thank you, Your Honor. It's been a pleasure working with you these past few years.
Are you moving to another office?
I'm actually moving home to New Mexico, Your Honor.
Oh, wonderful. Well, best of luck to you, Mr. Keeney. Again, the court appreciates all your assistance in the past. We'll make a note, but should this notice, we'll mail this notice to you, and obviously, but we'll note that Mr. Gomer will probably appear then on the August 22nd. Do you have his calendar? Will that work with his schedule?
I already placed it on his calendar, Your Honor.
All right, wonderful. All right. All right. All right. Thank you, Mr. Keeney and Ms. Bailey. That will conclude this matter. You can zoom out. We'll see you in August 22nd at 10:30, Ms. Bailey.
Thank you.
All right, you're welcome.
No, Judge.
Okay. Well, how do we know that?
I can ask them. One moment, please. Ashley, again, can you hear me?
Yes, ma'am.
And you say you have no contact with the other party, Armand Bailey, coming today?
No, I don't know if he's coming or not. I know he didn't come to the last one, and I called him and told him about it. I even called the morning of like twice.
Okay, I just
And
wanted to
left a
ask you
voicemail.
again. Okay, you're fine.
Mhm.
Thank you.
Present is Attorney Alex Goman representing the plaintiff Ashley Bailey, and Mr. Bailey appears to be present. Good morning, Mr. Goman and Ms. Bailey.
Good morning, Your Honor.
Is Armand
morning.
Bailey present on audio? It appears that he is not. This pre-trial conference was scheduled for 10:30. It's just 10:30. And Mr. Goldman and Ms. Bailey, do you expect Mr. Bailey will appear this morning?
No, Your Honor.
Right. The matter was last before the court on July 19th. Attorney Keeney was to file a default. It appears the default has been filed with the clerk by Mr. Goldman. And Mr. Keeney was also going to notice for entry a proposed default judgment. Of course, it's scheduled for hearing in today's date and time. So this fell through the cracks, Mr. Goldman.
That's correct, Your Honor, and I apologize.
Okay, so we'll give you another pre-trial in 30 days. And hopefully you can, it looks like you've already mailed a copy of this, trying to minimize mailing. You could mail everything at one time, not only the defaults, but also the proposed default judgment and notice of entry. So look like you just need to prepare a proposed default judgment and then mail that to Mr. Bailey along with the notice that you're going to submit this judgment for entry on a date we're going to give you in about 30 days. I think you need to give him 21 days notice. Can you get that judgment prepared in the next week or so?
Certainly, Your Honor. And
Right.
to clarify, do I need to file a motion for entry of that as well?
No, just a notice. No motion filed, just a
Okay.
notice of entry. So you inform Mr. Bailey that please take notice that the enclosed proposed judgment will be submitted to the court for entry on such a date and time via Zoom. And of course, the court will also mail out once again another pretrial notice. We need to close up this file. We need to. So hopefully we can do that. Okay, Nancy, you have a date.
Yes, Judge, I have Friday, September 20th at 1:30, 2:30, or 3.
No, I'm not going to do it till 3 o'clock.
Sorry,
About 1:30.
1:30,
Oh, 1:30 on September
20th.
20th.
That's good for me, Your Honor.
I'm sorry, that would work?
Yes, Your Honor.
All right. The court will mail out notice of a continued pretrial conference. We'll mail that to you, Mr. Goldman, as well as to Mr. Bailey. What's hopefully a final pretrial conference September 20th. That's a Friday, 1:30 p.m. Again, I think all you gotta do is prepare the proposed default judgment, have that approved by Ms. Bailey, and then to mail a copy of that to Mr. Bailey along with a notice. No need for motion, just a notice that the enclosed proposed default judgment will be submitted to the Braunlich for entry on September 20th at 1:30 via Zoom. And then write a Zoom ID number in your notice. And of course, if you're familiar with the history of this case, the court previously determined Mr. Bailey did appear back in May 31st, and there was testimony taken that Brandon Bragg is the biological father of the minor child Carson. So I presume all that needs to be referenced in the judgment. It's going out from the history on this matter. There's a child born out of wedlock.
Hold on, Your Honor, and I apologize. As you know, I inherited this from Mr. Keeney. I don't.
There was a motion filed to exclude the child of the marriage, that
Right.
child being
And
Carson.
at some point, Mr. Bailey stopped complying with the process, so I don't know if DNA testing was ever completed. Because I think prior to us providing the DNA testing materials, he refused to provide his address, and that's where the process fell apart. So I don't think.
Yeah. He never did the paternity test. After that, not the last court date, but the court date before that, when we discussed him taking the paternity test, he stopped answering my phone calls and my texts to get his address so I could mail him the test. He was supposed to set up a Zoom call with Mike, the previous attorney, to swab his mouth while Mike was on video so they could so he could have it. And he stopped answering. So at that point it was, I don't know. Yeah, he never did it.
So at this point, Your Honor, our proposed judgment would just say that this is a child of the marriage. Ashley would receive sole legal and sole physical custody. Armand's parenting time would be reserved, and child support would be ordered by front of the court. And if he chooses to start participating in a court proceeding later, he can bring the appropriate motions.
The court file does reflect notes from the court that I believe Mr. Bailey did appear on May 31st, and both he and Ashley did testify that Brandon Bragg and not Armand was the biological father of the minor child. And I do not recall, maybe Ms. Bailey could refresh court's memory. Did Brandon Bragg ever appear, Ms. Bailey?
No, Brandon never appeared because Brandon has some severe health issues going on and he is unavailable. I don't even have a phone number for him. Initially, he was going to take the paternity test, and I actually did have him take a paternity test, at-home paternity test, but he was unable to make it to court because of his reasons. So
Do you have the results of that paternity test?
No, I never sent him in because he went MIA again and I couldn't get a hold of him. So the only way that those tests would hold up in court, I was told, is if he was there to say that he took the test. Because I guess on at-home paternity test, it doesn't show the name next to the results. So the only way that that would hold up in court is if he was there to testify that he took that paternity test, and he wasn't able to do that. He is the father. Armand is not the father. Mr. Bailey is not the father. We have been separated for 8 years. He's been in California for quite some time. So he's not the father, but the issue is establishing paternity. He was going to all of these court dates. And then after we decided, okay, we'll just have him take the paternity test so we can keep, go forward with this divorce. Then he stopped answering the phone. So I don't know. Honestly, I don't know at this point.
The court did inform Mr. Keeney that the court would accept the over-the-counter DNA test, and the court was obviously that was never submitted by Ms. Bailey to the court, the results. But I think based upon the testimony of both Ashley and Armand, the court, as I recall, did make a finding that Armand Bailey is not the biological father of this child. So we can treat him as a product of this marriage.
I don't know if there was ever
We have
Order
testimony
of
from both
non-
parties. Then no question, Miss Ashley Bailey's part that Armand is not the father, but actually Brandon Bragg. I
Yeah.
think the court, I didn't order the transcripts, but again, I think the court may find that Brandon Bragg was the biological father. So perhaps you can put in the judgment that Armand is not the biological father of this child. And there was only one child born during the marriage, if the court recalls. Yes, Carson.
That's correct. And Your Honor, just to make sure that everything is wrapped up properly, I believe that Mr. Keeney prepared a proposed order to exclude child of the marriage. I don't know if that was ever signed, because I think we just assumed that DNA testing was going to be, that Armand and the other gentleman would comply. And I think it kind of threw a wrench into things when that stopped happening.
So there's an order in your file, is that correct?
I see that Mr. Keeney drafted one. I'm checking my file to see if we ever filed it.
Well, obviously it's not filed because it would have been presumably signed by this court. I don't see an order in the court file, but you can put in the judgment of divorce, Mr. Goldman, that the court's based on that sworn testimony taken on May 31st, 2024. The court determined that that one Brandon Bragg, B-R-A-G-G, and not the defendant Armand was the biological father of my child. So based upon the sworn testimony of the two parties in this divorce action, the court is comfortable signing a judgment of divorce, which excludes this child as being a product of the marriage.
Okay, very good.
Perhaps put a paragraph in the judgment to that effect.
I can do that.
Mail out notice to a final pretrial conference September 20th at 1:30. Hopefully we'll have everything in line. We can have a default judgment on that date and time. And Ms. Bailey, as far as you know, Mr. Bailey still resides on Edward Street in Detroit.
That is his mother's address. I know he lives in California, but I think that she forwarded his mail. That was the whole issue, was because he didn't want, I don't know if he just didn't want to give me his address in California. I don't know.
Okay. Do you text him? Do you have his phone number? Does he respond to text messages?
He hasn't responded to anything since 2 court dates ago.
The court's mailing to Mr. Bailey at the Edward Street address he trades not been returned as undeliverable, so you can use that as a valid mailing address, Mr. Coleman.
Very good, Your Honor. Thank you.
Okay, so we'll send out notice. Hopefully we can wrap this matter up on September 20th at 1:30.
Sounds good. Thank you, Your Honor.
All right, that concludes me. You can all zoom out.
Thank you. I appreciate it. Thank you.
We'll call the case of Leah Frank versus Anthony Frank. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the plaintiff Leah Frank. Ms. Frank is present, presumably, and as well as Anthony Frank. Good morning, everyone.
Yeah. Good morning, Your Honor.
Court is in receipt of a proposed consent judgment of divorce, which can be entered today if Ms. Nemec, the parties both agree to that the court waive the statutory 6-month waiting period. And the parties are separated. I don't know how long they've been separated, but perhaps we can address that in our testimony. Mr. Frank, are you still there?
We did just lose him, but I see.
It's back now. It left the
Okay, we'll give you a phone number, Mr. Frank. You seem to be in a poor, a weak area, so we're gonna give you a phone number you can actually call in, and you can appear by audio. Okay, you have a piece of paper and a pen?
I have an email.
Yeah.
Okay, write this down. We give you a phone number. You can call this phone number.
646 876 9923.
Do you happen to have a good connection now with me?
Well, it's okay. You keep it freezing up.
Yeah, I was in a machine with a metal roof. I thought that might, prohibit the connection.
Okay, we'll try this. And if not, you can call that phone number if you keep breaking up. Mr. Frank, what I was explaining is the court can enter the judgment of divorce today that you've approved, provided that you and Ms. Frank agree that we waive the statutory 6-month waiting period and enter the judgment today rather than in August. Under Michigan law, because there's children, there's a 6-month waiting period. from the date the divorce complaint was filed. This divorce complaint was filed on February 20th. I believe, yes, February 20th. So 6 months expires August 20th, but this court has the authority to waive that. Now, the judgment of divorce today, the court would do so if you both agree and you believe it to be in the best interest of your children to finalize things sooner than later. Okay, that's what the court's trying to explain. Do we have a catch that, Mr. Frank?
Yeah, I caught that.
All right, Mr. and Mrs. Frank, can you both please raise your right hand and be sworn, please? Right, Ms. Nemick, you can begin with Ms. Frank, please.
Okay, Leah, can you state your name for the record?
Leah John L. Frank.
Okay, and you are the plaintiff in this action for divorce, correct?
Correct.
At the time that you filed your complaint for divorce, had you lived in the state of Michigan for at least 180 days and the county of Monroe for at least 10?
Yes.
You and Mr. Frank were married December 19th, 2015 in Monroe County, correct?
Correct.
And you have two children, Abilene, who's 5, and Asher, who's 3.
Correct.
Okay. Are you currently pregnant?
No.
Okay. And are you stating to this court that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood of reconciliation?
Correct. Yes.
How long have you and Mr. been living separately?
In September of last year.
Okay. And is there any chance that the two of you would reconcile or get back together?
No.
So you signed yesterday a consent judgment of divorce, correct?
Correct.
Okay. And you had time to review that?
Yes.
You understood every part of it?
Yes.
Okay. Did you have time to think about it?
Yes.
Did you have time to discuss it with me?
Yes.
Is anyone forcing you or coercing you to enter into the agreement?
No.
Okay. Do you think that the provisions in the agreement regarding custody and parenting time of Abilene and Asher are in their best interest?
Yes.
Okay. Do you believe that the property division in the judgment of divorce that you signed yesterday is fair and equitable?
Yes.
You understand that signing it and submitting it to the court yesterday made it binding on you, right?
Correct.
So you can't come back and ask the court to change any of the provisions in that document regarding the division of property.
Correct.
So for example, there's a spousal support awarded in that judgment of divorce. You can't come and ask the court for more.
Correct.
Because it was non-modifiable, right?
Correct.
Okay. You understand that you could have taken this case to trial and the outcome could have been different. It could have been better or worse, correct?
Correct.
But rather than do that, you're asking the judge to take the judgment of divorce that you signed yesterday and also sign it, therefore making it an order of the court.
Correct.
Okay. Have you disclosed all of your assets to Mr. Frank?
Yes.
Okay. And are you satisfied with my representation?
Yes.
Okay. And my last question for you, as you heard the judge indicate, there is a 6-month statutory waiting period that I believe the judge said would be up in August, and it's obviously not August. Do you wish for the court to waive the balance of that waiting period?
Yes.
And is the reason that you want the court to waive the balance of that waiting period because you think it's in Abilene and Asher's best interest to have some finality and all 4 of you have the ability to move forward?
Yes.
Okay. I have nothing further, but Your Honor, it does look like we lost Mr. Frank. Oh, he's back again.
Right, Mr. Frank, were you able to hear your wife's testimony this morning?
I heard everything, but when it came to the August waiting period, and I heard everything before that.
She indicated she is asking the court to waive that. She believes it to be in the best interest of everyone, including you and the children, to waive the waiting period under the judgment of divorce now so you can move forward.
And on why it's in the best interest. I understand this is ultimately our chosen path and this is where we're going, but I would like just a brief explanation of why it's in the best interest to dissolve it today or August and what the difference is.
Because we've been separated for so long and we're ready to move forward.
And also, Ms. Frank, do you believe that there is any benefit in delay, considering you've indicated on this record that there's no chance of reconciliation?
Correct.
Ms. Frank, we're going to give you a phone number. You're breaking up, and we cannot record this. So get a piece of paper and a pen and call in, Mr. Frank.
I
go
have
back
my
in the
hand
house,
on
get a
it.
piece of paper and a pen. Mr. Frank, we're not going to continue this and breaking up. We need to record these proceedings, and we can't record these proceedings when you're breaking up. So please phone us. Okay.
Okay. I can.
Right,
I
Ms.
can.
Nimick,
I'm
we're
going
going to wait till
number.
Mr. Frank calls in. Of course, not going to continue with him breaking up every other word. Okay.
I've
So
got.
if you want to text him the phone number, Mr. Frank, call in, please.
Yep. Tell me the number. I've got it ready.
Okay.
646
Hello?
Yes, we're back on the record in the matter of Leah Frank versus Anthony Frank. Mr. Frank, are you currently present on audio?
Yes.
Good, much better. Okay, so when we were left off, you indicated you did not hear your wife's testimony regarding the 6-month waiting period. She testified that you've been separated since last fall, and there's no chance of reconciliation. And she believes it to be in the best interest of all parties, herself, you, and the children, to waive the balance waiting period and enter the judgment of divorce today rather than waiting till August. That was her testimony.
Correct.
All right, so sir, can you please state your name and current address for the record?
Current address?
Correct, your name and current address.
Yes, Anthony Frank.
Thank you. Mr. Frank, did you hear the testimony this morning of your wife, Leah?
I did.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Did you, in fact, assign your name to this proposed judgment, approving the terms and conditions contained therein?
Yes.
Do you understand that even though Ms. Nemec is helping facilitate resolution of this matter, she represents your wife, Leah, and her loyalties lie with Leah? Do you understand that?
I do.
Did you approve this judgment freely and voluntarily?
I did.
The last question, Mr. Frank, are you asking the court to waive the balance of a 6-month waiting period to enter the judgment of divorce today? Or do you want to delay this till August?
I think August is beneficial, actually, for a couple reasons. I mean, we're still going to remain in the same relationship. We're still going to be living separately. But, I think that both of us need to, for the children's sake,
I will have to pay the
Stop. Let him speak.
Do you want to talk in a breakout room, Ms. Nemec, with the parties?
I can.
If that's what happens, you have to enter some temporary orders regarding child support and some other issues.
Yeah, I understand, Your Honor. I will attempt to resolve this issue, but I think it's pretty clear that Ms. Frank's position is that the judgment of divorce should enter today. I don't understand why Mr. Frank disagrees if he's signed both the orders and the judgment of divorce, and it seems like this is only an attempt to delay proceedings, but I will attempt.
The court would note that the two of you, which is the court applauds you for being able to co-parent your children, you've agreed to joint legal, joint physical.
Right.
And Mr. Frank, the reality is, unless you think there's a prospect of reconciliation, there appears to be no sense in delaying this. I mean, for the benefit of the children, unless you think that Mrs. Frank's going to change her mind and wants to reestablish the marriage relationship, you want to move back in together.
No, I don't see that happen in 6 months. I mean, she ultimately yesterday said that she would love to see that down the road, but I don't know how true that is or not. My sole purpose is saying that I think we need time to not, to focus on the children here and not just say, okay, I'm free, let's start my new life here. Both of us need that time to really be mature and focus on that. And so that little buffer, just a couple more months, would say, okay, listen, yeah, I mean, this is pretty much final, but we're still technically married. I mean, that
makes no sense.
Yeah,
well, is that my right?
These children, you're always going to be parents of these children. You need to be friends. You need to get along. And obviously, you started on the right direction. You've agreed to co-parent children, which is wonderful. You've agreed to parenting time. You're in the minority where the two of you can work together for the best interest of your children. And you need to be on the same page for the benefit all the future years. You always need to make sure, Mr. Frank, your mom, the kids get a card from mom for Mother's Day, and likewise, mom gets a card for the children for Father's Day. None of that's going to change. It's just a matter of if you think there's a chance of reconciliation. Otherwise, we need to have some temporary orders regarding child support. I'm sure she needs assistance. If you're separated, we need to address some of these matters, such as not only child support. You've addressed. Spousal support. I mean, we need an order entered for spousal support. You're going to start paying spousal support on July 1st. So we need temporary orders. And the real estate. Who's going to pay the house payments between now
I pay all of that
in August?
Well, it's still in my name. So whether I sign this judgment or not, I'm bound to that until she refinances.
No, you're not bound by it. Until the court signs an order, you're not bound by anything, Mr. Frank.
Well, I mean, not bound, but I mean, that's my credit and my reputation there.
Okay, so are you going to who's going to make the payments then? We need to address all these issues. We need a temporary order. If you are refusing to to authorize the court to sign judgment of divorce today? Well, first of all, I mean, convince the court that it's not in the children's best interest. You may not like it, may not be in your best interest, but what about the children? That's what the court's focusing. So convince this court this morning that it's in the best interest of children to delay this matter.
Depending
Yeah.
You know,
my situation.
Yeah.
I don't know who's talking here.
All right, Ms. Nimick, do you want to talk with the parties or you just want to meet the court chair for Mr. Frank?
I'm fine, Your Honor. If you'd like to hear Mr. Frank, I obviously will have a response to whatever he has to say.
All right, so Mr. Frank, just tell the court, in your opinion, why it's in the best interest of children to delay things, to delay the inevitable. Normally, there's always some value and finality to all people, all human beings, including children.
There's a what in the finality? I'm sorry, Judge.
There's value to finality, so people know where they're going.
A 3-year-old and 5-year-old.
Children to expect that mom and dad are going to get back together. I mean, that's cruel if in fact you think that you're going to try to convince the children that mom and dad are going to get back together.
Yeah, of course, our 3 and 5-year-old hope and wish for that, and we don't plan to have that discussion with them anytime soon. We plan to just love them as we have been. But my sole position on whether it happens today or August would be just like a cool off period where, as far as the children's interest, that neither one of us say, okay, I'm free from this divorce. I'm going to go off and, do what I want now. And the freedom aspect overtake the position of this has to be about our children from this point. So it's just basically a buffer to have a cool off period and say, okay, we have a few months here, and
the court's not going to allow you, Mr. Frank, to decide that cooling off buffer period. The reality is, if it's the best interest of children to finalize things. So I'm going to have you talk with Ms. Frank. If in fact you think there's a prospect of reconciling, then that's one thing. But that's only a basis to delay this if you think there's a chance of reconciling. So I'm going to have you talk with Ms. Frank. Maybe she's changed her mind. So we're going to put you in a break room. You can talk with Ms. Frank. And if in fact she agrees that there's a chance of reconciliation, then perhaps the court will delay this. Otherwise, it appears that the court should end the judgment of today's. So we're not holding out false expectations for the children.
Right. That's been my heart from the beginning is reconciliation.
Hey, you need to hear from Ms. Frank. So Ms. Frank, we're going to put you in a breakout room. You can talk to your husband and let him know whether or not there's a chance of reconciliation. All right, Ms. Nimick, Mr. Frank, you've had a chance to talk with your wife. Do you believe there's a chance of reconciliation in the next couple of months?
Not at this point in the next couple of months, but down the road, who knows with things. I do know that yesterday there was a huge push in the 11th hour to get me to sign papers that I didn't really even get to look over the revision. I mean, I looked them over.
Hold on, stop right there, Mr. Frank. I thought you said you reviewed everything and then you understood everything and signed up freely and voluntarily. Are you now saying that you did not sign it voluntarily?
No, I did. I'm just telling you that why I have a reasonable level of discomfort is yesterday they messaged me with the revision of this and said, you have a half hour to sign it. And I looked it over. I did, and I still signed it.
Court date. Mr. Frank, we had a court date today. Mr. Nimick is trying to be efficient. We had a court date today.
Right, I understand.
Your Honor, and what actually happened is I changed one sentence in the judgment of divorce that Mr. Frank has had since last week sometime, I believe. And that sentence was changed at his request. We redefined 1 week of vacation from 7 days to 5 days. There was one sentence change. I did advise that it needed to be signed within a half an hour in order for me to get it to the court in time for the court to have access to it before this morning.
All right, so Mr. Frank, are you asking for an adjournment so you can consult and retain an attorney? Is that correct?
I personally would like that, but I know that Leah is just ready to be done with it.
Right. All right. The court. How much time do you need to hire an attorney? Can you do that in 2 weeks?
Well, listen. Let me finish the sentence. I don't think an adjournment's going to change a whole lot. I just have to say that Leah's. It's not even about the relationship or salvaging it, but Leah's.
Mr. Frank, do you want to talk to an attorney? I've got the other parties waiting. Again, I understand you want to talk to begin. The reality is, if in fact you don't want the court to enter this judgment today, and you want to talk to an attorney, the court will adjourn this, give you a chance to talk to an attorney.
Yes or no?
Mr. Frank?
I'm sorry. Yeah, I heard her talking too. I'm sorry. Yeah.
All right, court's going to adjourn this matter. Mr.
Gosh.
Frank,
No,
contact an
I don't
attorney
think-
forthwith. We're not going to play games, Mr. Frank. The court is
I'm
a
not.
busy
I'm
docket.
actually.
Ms. Nimick is busy, so we're going to give you another date. Would
Michael.
2 or 3 weeks be
Yeah,
sufficient?
I'm listening. Listen, let's get it done. I'm telling you, I'm not comfortable with this, but I don't think it's going
Right,
to change
court-
much.
Mr. Frank, stop right there. We're not going to proceed any further this morning. You're saying you're not comfortable with this, of course, not proceed with
No,
it.
Judge,
And through a
Judge,
judgment, you're not comfortable with it. So stop
Hey,
talking,
let
Mr.
me-
Frank. We'll
let me-
give you a date. Ms. Nimick, what day in July are you available on a Friday?
Ms.
Your
Neiman, can we
Honor.
please?
Ms. Cindy?
Your Honor.
Hold on.
May I? Yeah.
No, Mr. Frank, I got other matters waiting. There's, we don't have time to talk. You can talk with an attorney about these matters.
No,
I'm
there's
done.
no attorney. Let's just get it over
Ms.
with.
Nimick, hold on. Mr. Frank, do not interrupt, please. We're looking at some dates in July.
The earliest
don't wanna-
available in July, Your Honor, it's July 19th.
Your
Ms.
Honor,
Nimick.
I don't want to do this to her. I don't want to do this.
Do anything about what he's saying on the record, Leah, okay?
I don't want to do this to her. I want to finalize it. I'll
July
just do
19th
it.
at 9 o'clock. Ms. Nimick, you available July 19th at 9 a.m.?
I am, Your Honor.
All right, this matter is adjourned to July 19th, 9 a.m. Mr. Frank, please consult an attorney so we can move forward with this matter. Talk to an attorney and find
Your
out what
Honor.
your options are. We'll mail you notice
Your
at
Honor.
the Huron River Drive address, and this matter is concluded. We're adjourned. Have a good rest of the day. You can zoom out.
Your Honor.
All right, the court will recall the case of Ricky Campbell versus Aaron Hubbard. Both parties are present this morning for a pretrial conference being conducted via Zoom. They've confirmed with Mr. Walker for the front of the court. The court notices a short-term marriage of 5 months. Parties have been separated since March of 2023, over a year ago. Mr. Walker, have you been able to discuss and sort through with them their issues and dispute?
Yes, Your Honor. I believe the parties have a full agreement, which I am prepared to put on the record if you want.
All right, so Ms. Campbell, Mr. Hubbard, listen carefully. Mr. Walker is going to state what he understands to be your agreement. And after he does so, I'm going to turn to each of you individually and ask you to confirm that's your agreement. And of course, it's your obligation, Ms. Campbell, you're the plaintiff. You need to prepare that judgment and submit it to the court. You've got to sign it, prove it. You've got to give it to Mr. Hubbard, and he's got to sign and prove it. You'll now be divorced till the court signs a written judgment. Okay?
Okay.
All right, Mr. Walker.
Yes, Your Honor. Regarding custody of the minor child, the parties have agreed that they are going to share joint legal custody, and plaintiff mother is going to have sole physical custody of the minor child. Parenting time is going to be reasonable and liberal as the parties agree. Child support is going to be reserved. There is no public assistance involved, so the parties have agreed that child support is going to be reserved. Neither party is requesting spousal support, and it will be forever barred. The parties have already divided their personal property, so any personal property they have in their current possession, they will keep. Same with vehicles. They each have, if they each have a vehicle in their possession, they will keep that vehicle, and they will, the other party will not be responsible for that vehicle in any way, shape, or form. The parties do not have any real property to divide. Parties have agreed that they will keep their own debt that's in their name. There is no joint debt. Any pensions, 401ks, IRAs, if either party has those, they are going to keep their own free and clear. There is one bank account that is joint at Chase. It's a checking account. It is agreed that the defendant father is going to be able to retain that account, and plaintiff will cooperate in trying to get her name off of that account. If that's not possible, then defendant will close the account and open up a new one. And he will keep any money that's in that account. For tax purposes, minor child as a dependent, plaintiff mother is going to be able to file for taxes with the minor child every year. And I believe, Your Honor, that is the extent of the agreement.
Thank you, Mr. Walker. Ms. Campbell, did Mr. Walker accurately state your agreement?
Yes.
All right, Mr. Hubbard, did Mr. Walker accurately state your agreement?
Yes, sir.
Okay, this Chase bank account, what the court suggests is it's more to you rather than fool with getting Ms. Campbell to sign off on it, just go close out the account.
Yes, sir.
If it's a checking account, write out a check for find out how much is in there, just close it out and then do whatever you want with the proceeds. If you want to open a new account or take it, the cash out of there, close that out as soon as possible. That's probably easiest, okay?
Yes, sir.
Thank you. Is it true, Ms. Campbell, you filed a complaint for divorce with this court on about February 20, 2024?
Yes.
Is it further true that on the date you filed the complaint, you've been a resident of the County Monroe for at least 10 days in the state of Michigan, at least 6 months?
Yes.
Is it further true that you married Aaron Hubbard on October 9th, 2022, and you separated in March of 2023?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance that the marriage can be preserved?
Yes.
Is it true there's just one child born during your marriage, namely Winter?
Yes.
Any other children born or adopted during your marriage are still minors?
No.
Are you currently pregnant?
No.
Okay. Mr. Hubbard, could you please state your name and current mailing address for the record?
Aaron Hubbard.
Thank you. Mr. Hubbard, you're currently in active military, is that correct?
Yes, sir.
So it's good mailing address, okay. Well, thank you, what you do for our country, Mr. Hubbard.
Thank you, sir.
Mr. Hubbard, did you hear the testimony of your wife, Ricky, this morning?
Yes, I did.
Was her testimony true and accurate to the best of your knowledge?
Yes, sir.
Do you have any questions for the court?
No, sir.
Okay. Well, the court applies you for reaching your own agreement. All we need is that judgment divorce. So, Ms. Campbell, I don't know, you've already completed it, you mailed to Mr. Hubbard, but I don't know if you addressed everything in that judgment, for example. Did you put in there joint legal physical to you, reasonable level of parenting time?
I'm sorry, I didn't know the last sentence you said.
The agreement that Mr. Walker stated, was that all addressed in your judgment? Do you need another copy of this judgment?
Yeah, yes, I filled it out when we were talking to him.
Oh, I thought you said you mailed it.
No, I thought I did, but it was a different paper that
all right.
Yeah, so I have to mail it.
Okay, you got the form judgment of divorce, says judgment of divorce at the top, correct?
Yeah, I have it. I have to mail it to him.
Okay, and so you need to complete it all, and you filled in all the blanks, joint legal physical to you, reasonable level of parenting time for dad, child support reserved, spousal support is barred, each keep their own property. Each will keep their own pension benefits, correct?
Correct.
Then you need to sign the bottom of page 2. Do you see that? But by maybe it's page 3, you sign your name.
Yeah, I will sign it. I just will need to mail it to Aaron to get his signature.
Okay. Okay, then you're going to mail it to Mr. Hubbard. Mr. Hubbard, will you be in Michigan at all in the near future, in the next week or so?
No, sir. The time I will be back in the States is probably in August.
Okay. You're overseas?
In England, yes, sir.
Where in England?
I'm in England, yes, sir.
England, wow. It's amazing, the technology. So, Ms. Campbell, you have his address, mail it off to him, and Mr. Hubbard, you need to also sign your name and date this judgment of divorce and mail it back to Ms. Campbell. Ms. Campbell, you can drop it off to the courthouse. And once it's dropped off and you see both signatures there, the court will sign that, and you'll be mailed a copy of that once it's been entered.
Okay.
So, Ms. Campbell, do that while it's fresh in mind, and send it off, because it could take some time through the mail. And Mr. Hubbard, when you receive that, timely address it. So you can clear premarital status, okay? Do either of you have any questions for the court? Well, based upon the testimony that's been presented this morning, as well as complaint filed this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. According upon receipt of the consent judgment approved by both parties, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from the bonds of matrimony. All right, that will conclude this matter unless you have any other questions. And if you don't, then you can zoom out and have a good rest of the day.
Thank you, Your Honor.
Thank you.
All right, thank you.